Morning, everybody. Welcome to our latest Brexit webinar instalment. Today we'll be looking at finding effective and practical solutions to disputes post-Brexit. My name is Cheryl Palmer-Hughes. I'm a partner in our international serious injury team at Irwin Mitchell, and one of the main areas of focus of my practice is looking at cross-border disputes involving injury in one country and pursuing it in the jurisdiction of another. And that's a topic that we're going to be looking at in a broader sense today. I'm sure that you're all aware that here at Irwin Mitchell we've been keeping a very close eye on Brexit and issues that could affect our clients and contacts. I sit on the Law Society Special Interest Group in international law, and we've been looking at, on the one hand, campaigning for the UK to join Lugano, and we will hear about that shortly, explaining the differences between the different conventions. And on the other hand, we've been keeping a close eye on any developments within private international law and indeed looking at proposals as to whether we make any changes post-Brexit. But we do find ourselves in the unusual situation, having just passed the 5-year anniversary of the UK's decision to leave Brexit, still not knowing exactly where we stand. And one particular area that we're going to look at today involves civil litigation across a number of disciplines. It's something that will affect many of our clients and our contacts, from those who are injured abroad to those who've got family disputes and need assistance with looking at what might happen if a child is in another country within the EU, to looking at commercial contracts and beyond, including employment contracts and all sorts of disputes. So this is quite a wide-ranging topic, and I'm very pleased to be joined by my colleague Jane Anderson, who's a practice development law with a background in commercial litigation, along with our guests from IPOS Mediation. We've got Rebecca Attry and Henrietta Jackson-Stopps. I've had the pleasure of hearing Rebecca and Henrietta presenting before, and what really strikes me is that while as lawyers we could talk about the academic implications of Brexit and civil litigation, there's a real focus on what we can do for our clients and finding pragmatic solutions to cross-border disputes, and that is something that we're going to be taking through today. And I'm sure it's going to be very useful for everybody on the call. Now, we do have a Q&A function, so if you have any questions for anybody presenting, or indeed anything to do with the topics that we're touching on, if you want to pop those in the Q&A box, we will look at those and we will endeavour our best to answer them at the end. But if we run out of time, or if it needs a little bit more detailed consideration, we will come back to you. So I very strongly encourage you to pop those questions in the Q&A box, and we'll come back to those at the end. I'm now going to pass on to Henrietta.
Thank you, Cheryl, and thank you for the invitation to Rebecca and I to come and speak to you today. As Cheryl said, my name is Henrietta Jackson-Stopps, and I run IPOS Mediation alongside my own mediation practice. For those of you who don't know us, we're an established provider of dispute resolution services with over 25 years experience. We offer the skills of some of the most experienced mediators to the UK and global disputes market, and we are instructed by market-leading law firms and corporates, and have mediated, I think, between us about 20,000 disputes. Our expertise covers a broad range of disputes, including commercial, workplace and employment, public sector and family, business and trusts. I'm delighted to be joined today by Rebecca Attry. Rebecca has over 35 years experience in assisting global businesses and individuals to resolve disputes and reach agreements. Prior to becoming a full-time mediator, Rebecca ran her own niche solicitors practice, specialising in contentious and non-contentious international commercial advice. She's been described as outstanding and hugely impressive, and she's been mediating face-to-face and online before the pandemic for over a decade, and is recognised by the legal directories for her expertise. So I'm going to hand over to Rebecca. Thank you, Rebecca. And Rebecca, you're on mute.
Can you hear me now? Good. Okay, start again. So thank you very much indeed for the very kind invitation from Irwin Mitchell to present this morning. Good morning to all. good afternoon, good evening if you are joining internationally, because this is an international topic, and I see from the list of registrants that people are joining from all around the globe. Thank you to Cheryl and to Henrietta for the warm introduction. So this is a topic which is close to my heart, having been an international solicitor for years and now an international mediator. And really, it's all about finding effective outcomes to disputes, particularly in an international context. And to do so, we need please to board a plane, a virtual plane. I'm going to take you on a virtual flight. This may be the most exciting journey that you have been on for some months, and it is of course pandemic friendly. So if we may take the next slide, please, where we show the itinerary of where we are going to be going. If we could just move, thank you. So here is our itinerary: London, Brussels, Lugano, The Hague, New York, Singapore, all in the next about 30 minutes. So we're going to condense our flight time virtually. And some of you who are joining who are international lawyers may be saying, Rebecca, you haven't got Rome on there. Well, yes, I'm disappointed I haven't put Rome in there. Rome is one of my favourite cities of the world. I speak Italian. For those of you familiar with international law, Rome Convention and Rome Regulation deals with governing law. Today isn't about the governing law, but we may touch on that in our Q&A. Today is about forum, today is about jurisdiction, and so no need to go to Rome. Sorry, maybe another day we may go there, but this is our itinerary, and let's see what we will find in each of the countries where we visit. So if we could have the next slide, please. Let's look at our agenda. And really, there's been a lot happening since the 1st of January this year when Brexit happened. And what I'd like to focus on here in this webinar is the question of enforcing judgments, enforcing arbitral awards, and enforcing mediated settlement agreements. What's happening now in terms of actually getting a practical outcome from your dispute? And really what I'd like to show you is why I believe, and I think Hetty will, I'm sure, agree with me, that mediation is a golden opportunity, because it's likely to achieve a practical, enforceable outcome internationally, more so even than arbitration and the courts. So just moving on through to the next slide, please. Let's just stop and think for a moment. Why is enforcement so important? And it's basically because we want to avoid what I would call a Pyrrhic victory. So let's say you've received a judgment or an arbitral award, or you've agreed a mediated settlement agreement in your favour in England. Fantastic, marvellous, congratulations. But the other party in the litigation has the means to pay the judgment, but refuses to do so. So you've got your award, your judgment, but how are you actually going to get your, usually it's going to be money. Enforcement may involve seizing and realising the assets of that other party in order to meet that judgment or award or settlement agreement. But the defendant's assets are outside the original jurisdiction. They're not here in England. So what are you going to be able to do to go outside of England to try to enforce overseas? And if you can't enforce overseas, you could end up with a Pyrrhic victory where you've actually spent a huge amount of time and money getting to an outcome, but actually you can't get hold of the money because the assets are elsewhere. So let's look at how does this play out from the point of view of, firstly, litigation, secondly, arbitration, and thirdly, where I think the result is the best, is through mediation. So just moving on to the next slide, please. Our first leg of our journey is going to go from London to Brussels to Lugano, and we're going to take some short stops there. We're not going to loiter long, because everything that we had that was beneficial in Brussels before Brexit has now pretty much gone away. And there is left the hope that we might be able to recover some of the help that we got through Brussels, through Lugano, but that at the moment is not actually looking terribly encouraging. And I'll tell you more about that as we go through. But if we just move to the next slide, perhaps I can share with you where we are with regard to Brussels right now. There is a Brussels regulation which previously said, and still says, all countries in the EU, if you have a judgment in one country, it will be recognised and enforced throughout the EU, or indeed the broader EEA jurisdictions if you're including Lugano. That has gone out the window. I have a window right by me, so sometimes I use my props. So here we are. It's all gone out of the window with Brexit from the UK point of view, other than cases where a judgment was given before the 31st of December, or they were ongoing. So we've got some transitional arrangements with things that were still happening as we were Brexiting. But going forward, the bottom line is, if you have a judgment from a UK court, it is no longer directly enforceable in the other EU or EEA jurisdictions as a result of Brexit. But there's some hope on the horizon, and I'll share with you what we can be doing. And in order to do that, we need to jump back on our plane, fasten our seatbelts, and on to The Hague, please, if we could move to the next slide. So what is happening in The Hague, other than that it's, according to this picture, a beautiful sunny day? And let's see if there is some hope on the horizon. Well, the answer is there is, with regard to recognising and enforcing judgments through different countries. If we could move to the next slide, the Hague Convention on the choice of court agreements is the relevant piece of legislation, and the good news is that it's Brexit proof, because it's a Hague Convention. It's not something that is linked directly to the EU, and we say in the UK that it still applies to the UK from its original entry into force when it first came in on the 1st of October 2015, brought into our UK law. So we say we can look at this document and we can see how can we recognise and enforce. Next slide. But this is where, surprise, surprise, there is a different view from the EU. The EU says, no, sorry, UK, you joined in your individual right only from the 1st of January 2021. And so actually the Hague Convention only applies to the UK from the 1st of January this year. And as to what about a case where it's begun in an EU member state, that's a whole complicated story that I won't go into today, but basically each country has got its own view about that. So harmonisation has really started to fall away. But on the basis that the Hague Convention is useful and interesting for UK companies, let's see what it actually says, whether it's from 2015 or 2021. Next slide. So where we have cases that have begun after the 1st of January 2021, and I'm still here in the case of courts and litigation, what we say is, does the Hague Convention apply? And the answer is yes, it does, if there's an exclusive jurisdiction agreement. And from the UK perspective, as long as that's been since 1st of October 2015, then that will work. And if the court is in a country that's a contracting party to the Hague Convention. So basically, exclusive jurisdiction clauses are good because they come within the Hague Convention. But it has to be a true exclusive jurisdiction clause, and Hetty will pick up more on multi-tier dispute resolution clauses very, very shortly. So next slide. So if then the English court has jurisdiction under the Hague Convention, then that judgment that the English court gives is enforceable in the EU and the other Hague contracting states under that Hague Convention. Which countries are they? And I can sense you may be wondering. So it's Denmark, the European Union, excluding Denmark, because Denmark specifically signed in specifically on their own, the UK, Mexico, Montenegro and Singapore. We hope that more countries will join as time goes by. Something, by the way, just to bear in mind is that there are some exclusions, some matters that aren't covered by the Hague Convention. Interested to see there's quite a number of people joining it from HR and from employment law areas. Of note is that the Hague Convention doesn't actually apply to cases relating to employment. Next slide, please. So if the Hague Convention applies, we have an exclusive jurisdiction clause, great. But what if the jurisdiction clause is non-exclusive, as has often been put in many contracts. Well, then we come to what I would call the spaghetti bowl. And this is where it gets expensive and complicated, because if you've got a non-exclusive jurisdiction clause, or the country where you're seeking to enforce is not a signatory to the Hague Convention, then basically you have to rely on individual bilateral treaties that may be pretty old and difficult to trigger. Many countries do have bilateral arrangements with the UK, but frankly, they need dusting off because nobody's looked at them for a long time. There are bilateral agreements between the UK, for example, with Austria, Belgium, France, Italy, Germany, Norway, and the Netherlands. But you can imagine that if you are actually seeking to enforce your court judgment in each of those countries, you haven't got a one-stop shop as we had previously under the Brussels regulation. You've actually got to go with each of those bilateral treaties. So it's possible, but it's expensive and it's complicated. So next slide. What does this mean in practice for a cross-border contract or subsequent dispute resolution strategy? Well, thinking at the outset, what's your favoured court? And there are many criteria that you may be looking at. I think the big one for many companies is the ability to recover their costs if they win, because that's already another way that it could be a Pyrrhic victory if you spend a great deal of time and cost in seeking to pursue a claim, but then you can't get a costs award in your favour. So, for example, in many states in the US, that is the case. Of course, in the UK, generally, there are costs awards in favour of a winning party. But many issues there about favoured court, which law will be applied. Are you likely to need to enforce a judgment given by your favoured court in another state? So are you actually going to need to go where we are looking at this discussion? There are other, what I would call softer issues around the DR strategy. Will the counterparty be unable to ignore a judgment given by the chosen court for reputational reasons? Will it just be too hard for them to turn a blind eye and not to do what the court in another country has said? So getting it right from the get-go, having an exclusive jurisdiction clause, selecting your favoured jurisdiction will point to the court that you're going to get the best result and the easiest enforcement from. But as I say, it isn't as simple as that. There may be other tiers to put in there that Hetty will tell us about in a moment. I think the other thing to bear in mind is a little bit of crystal ball gazing. Time goes by. When you first enter into a contract, something that you may be looking at that would be very relevant is where actually are the assets of the other company that you're contracting with, and working out actually if we do need to enforce which are going to be those relevant countries. But of course things can change. It's possible that where the assets are at the time of the contract and then 5 years later at the time of the dispute, the assets could have moved. The business could have been wound down in one country and increased in another. So getting an idea of what your counterparts' business strategy and view is, where are they looking to develop, can be quite relevant from that point of view. Next slide, please. So, yeah, we're still on our journey. Shall we go back for a moment to Lugano? We touched very briefly there. Yes, I'd like to take you there. So please, ladies and gentlemen, fasten your seatbelts and let's take a short hop over to Lugano. Next slide, please. Why are we coming to Lugano? Because there is an oven-ready option there, which could actually really help businesses in the UK and indeed solicitors and barristers and mediators, because the Lugano Convention has a similar regime to the Brussels regulation, saying judgments obtained in one country can be enforced and recognised in other countries that are within the EEA. The EEA, of course, being the European Union countries plus Norway, Iceland and Switzerland, but of course not the UK. So the UK government was quite quick off the mark and said, yeah, we have Brexited, but how about we rejoin the Lugano Convention? That's nothing to do with Brexit. why don't we see if we can do that? So the UK applied to rejoin already on the 8th of April last year, but the decision as to whether we're going to be allowed to join the club or not has taken some time and is still pending. Interestingly, Denmark, Iceland, Norway and Switzerland have all unilaterally agreed that the UK can join the Lugano Convention. What we're waiting for is for the European Union to agree as a trade entity. And it's not looking great. A couple of months ago, the EC Commission rejected our application, but that's not the end of the road. The final decision rests with the European Council, and the European Council is entitled to take submissions and to hear opinions in making their decision. And so we wait to see what the European Council has said, will say. Some commentators say, look, it's pretty hard for the European Union to say no when the other states have said yes. I'll leave that with you to decide whether that is the case. But somebody else I spoke to said a veil has come down in the EU regarding this, and there is little to be heard about how things are likely to progress. In the meantime, our Parliament has been getting ready to join Lugano, rejoin, and there is a bill going through Parliament that's all ready to be able to press a button and enforce if we are given the go-ahead. So if we do join Lugano Convention, then English court judgments will take on a new strength because they will then be able to be recognised and enforced through the whole of the European Economic Area. So that's something that we should be watching. And from my perspective, I say we live in hope. Next slide, please. So pending that decision about Lugano, I think we've got to get out of Europe on our flight, and we've got to go on the long haul flight over to New York. Why would we do that? Because I'd like at this moment to leave on one side the question of court judgments, and I'd like to dip into the realm of arbitration and specifically arbitral awards. What's the position with regard to arbitral awards and getting an arbitral award recognised and enforced in another country? So this again is Brexit proof, and on the next slide we'll see that there is a very useful, very established New York Convention, 1958. 166 states have ratified it. I've got all those flags up there on the slide there of the signatories. So a very well acceded to convention, one of the most important and successful UN treaties in the area of international trade law. It's exciting, even though it's been around for a while. It gives a simple, streamlined approach to global enforcement, irrespective of the arbitral body or the local rules. Basically, if you have an arbitral award made in a country that has signed up to the New York Convention, or rather with the seat there, then you can recognise and enforce that arbitral award in any of those other countries that have ratified the convention. So a much more global approach to arbitration. So I'm hearing anecdotally of more and more companies including now arbitration clauses as their point of last recourse in the event of a dispute, rather than the courts, because of the ability to enforce globally pretty much any arbitral award. Next slide, please. So having seen that arbitration is going well in terms of international enforcement, there is hope for the courts, but at the moment it's rather more complicated. Let's just have a think about mediation and what happens with mediated settlement agreements. And for this, we can take our final trip to Singapore. And what I'd like to share with you here is a really interesting and exciting development in the field of recognising and enforcing mediated settlement agreements that has come out of Singapore. So on the next slide, we'll see that there's the UN Singapore Convention. What I'm talking about here is how do we enforce mediated settlement agreements? Well, they're enforceable in England and Wales if there's already litigation pending, they will then be made subject to a Tomlin order. So mediated settlement agreements that are purely domestic, certainly within the UK, have teeth. Sometimes people will say to me, you know, is mediation a soft option? What's the outcome? Is it going to be something that we can really use? And the answer is absolutely yes, you can domestically. But when it comes to looking at an international mediation, should you need to enforce it, and we may talk a little more about that in the discussion, how often is it actually necessary? There isn't any EU enforcement of mediated settlement agreements post-Brexit. There's no EU coordinated approach from a UK perspective. So if you have a mediated settlement agreement that's entered into in England and Wales, you're at the moment relying on the goodwill and intent and contractual force of the settlement agreement for it to be properly actually seen through and done in practice. But what I would say here is that as a mediator, I see, and all mediators see, their role is to reality test with the parties and to check in with them. Can they do what it is they're proposing to do in the settlement agreement, and will they do it? And if you get a whiff that actually maybe it's not entirely practical, as a mediator, your role is to talk to them about, well, why don't we put something in that you can do? And are you comfortable with this? And talking through it. And that's where actually enforcement of mediated settlement agreements is perhaps less needed, because you've got something that people have consensually agreed to. At a mediation, of course, it's up to the parties to reach their decision, whereas in courts and arbitration, it is somebody else imposing a decision upon them. So next slide, while we're thinking about the Singapore Convention, what's happening with this UN Singapore Convention on Mediation of 2019. So 53 states have already signed the Singapore Mediation Convention, but notably the UK hasn't yet. That's a good word that mediators like to use. Yet implies that there's hope. The EU, or indeed Australia, for example, they haven't signed. But what the convention allows for is for the direct enforcement of cross-border settlement agreements between parties resulting from mediation. So similar kind of regime to the sort of regimes that I've been alluding to by reference to court decisions. So the signing of the convention was a big event. Actually, many were surprised that there were 53 states who signed, but as many of you will know, that signature doesn't necessarily mean coming into force. It then needs an accession by each country. And actually, the countries that so far have signed up and are operating the Singapore Convention are Singapore, Fiji, Qatar, Saudi Arabia, Ecuador and Belarus. We hope that many more countries will be joining. Notably, the UK is about to enter into a consultation about should we or shouldn't we be joining the Singapore Convention. It'd be interesting to see what others, particularly perhaps on this call, think about that. Next slide, please. So the Singapore Convention, the UK hasn't signed up to, but it doesn't mean to say that it is not relevant to us and to disputes mediated in the UK, because actually it isn't bound by reciprocity, and many will call the Singapore Convention as making the mediation stateless, because basically the convention applies where you've got at least two parties mediating, and the place where the settlement agreement is to be performed, or where the subject matter of the settlement agreement is most closely connected, is in a state that signed the convention, then the convention will apply. So it's perfectly possible even today that I mediate an international dispute here in the UK, even though the UK hasn't signed up to the Singapore Convention, it could apply because of this fact that it isn't based on reciprocity. Next slide, please. So that is where our journey for a moment should be paused, and I'll pass on to Hetty, but just to really summarise what's new post-Brexit, there's a lot that's new with regard to enforcing judgments. The position with regard to arbitral awards remains the same and strong. And with regard to enforcing mediated settlement agreements, there are things that are in the pipeline and to come. So I hope you've enjoyed our flight so far. London, Brussels, Lugano, Hague, New York, Singapore. We're going to stop for a moment to refuel, and I'd like to pass over to Hetty, please.
I'm here. Sorry, for some reason I dropped off there and then couldn't unmute myself. I missed the last bit of Rebecca's thing, but I'm bringing us home, I think, to the beginning of our contracts. It's clear, as Rebecca has indicated, that serious thought needs to be given to dispute resolution clauses. I spent 6 months in private practice as a professional support lawyer in litigation, and there was many a day when the corporate team would come running and say, we're about to sign this contract, what do we put in the dispute resolution provision? Clearly, because the clause often comes last in the contract, it was thought of last. But as Rebecca has indicated, it's incredibly important to give real thought to your dispute resolution clause. And I think from our point of view, a multi-tiered dispute resolution clause is the way forwards. Issuing litigation or arbitration proceedings is often a nuclear option to a relationship. A multi-tiered, or also known as an escalation clause, allows parties to take a number of steps to resolve their dispute before starting proceedings if settlement is not achieved. Many multi-tiered clauses include negotiation between senior managers before then mediation. The utility of including the negotiation phase is debated. Many in-house counsel feel that it is likely that this negotiation would take place in any event without needing to be prescribed by a contract. Indeed, technically under English law, such a clause has no legally binding effect. However, it can be good if a conflict arises for everyone to be able to point to the contract and say, we agree we would negotiate, so let's give it a try. However, often direct positional negotiation fails because each party is trying to win. They're trying to prove themselves right. And this is, of course, where a mediator offers a different solution. They can step in and facilitate the communication between the parties using tried and tested techniques. Mediation can often achieve settlements that have previously been thought to be impossible during direct negotiation. I've also heard from in-house counsel who've said that including mediation in a contract is beneficial because it allows them to insist on mediation without the loss of face that perhaps internal stakeholders might fear. I know from in-house counsel in litigation teams that when they suggest mediation to the business, sometimes the business push back saying, you know, we want to prove ourselves right, we want to win. But of course, if it's written in the contract, you can just rely on that and use that to bring the other party to the mediating table. And of course, it does have an 80+% chance of success. And even if settlement isn't achieved on the day, there are great benefits in perhaps having narrowed the issues, put oneself in the other party's shoes for a day, or gathered key information which might, in the course of litigation or arbitration, take months to come out. Many a mediation that we deal with, not many, several mediations that we deal with don't settle on the day, but settle shortly after, with or without the continued assistance of the mediator. We do have precedent mediation and multi-tiered clauses, which we would encourage you to consider putting in your contracts. They meet the test of certainty and the exclusive jurisdiction requirement for the Hague if litigation is follows, and they incorporate our mediation procedure. The mediation procedures helps parties get to the mediating table. We often find ourselves in the position where we are, as we put it in our office, mediating the mediation. We are in the instance where parties can't agree on the mediator. And this happens quite often, and I think often as a result of game playing by the parties, we can help them come to a decision on the mediator. And the procedure also has time limits written into it, which help the process keep moving forwards, which is particularly important where there is a need to resolve the dispute as soon as possible. For example, in an urgent supply contract, if you want to get a resolution as soon as possible, then mediation might be your answer. It also means that if one party doesn't follow the procedure, then they may be at risk on recovering their costs in the litigation or arbitration as a result of their unreasonable refusal to mediate. We're happy to circulate the clause afterwards, but you can find it on our website. And I will now hand back to Rebecca to sum up.
Thank you very much indeed. If we could just go through 2 slides, please. So to summarise, I think top tips for finding effective and practical solutions to disputes post-Brexit. I think firstly, review your contracts. Yes, it will take a little while for this to filter through, and hopefully you won't need to be looking at the clauses and that you won't have any disputes, but should you have them, having an effective multi-tier dispute resolution clause is very important. Considering having a backstop of exclusive jurisdiction at the very least, so that then you can take hold of the benefit of the Hague Convention. Consider whether, pending the UK signing up to Lugano and being accepted there, should you actually move to arbitration and have an arbitration submission clause rather than the courts. And very definitely consider mediation, whether you include it in the multi-tier dispute resolution clause, as Hetty has said. Even if you haven't got it there, consider mediation, because I hope that you can see that as a result of what I've talked through in this presentation, for many reasons, you're actually likely to achieve a practical, enforceable outcome internationally. And as Cheryl said at the outset, mediation has a very broad application. It's not just for commercial contracts disputes. It can cover property, employment, probate, consumer law, a whole range of areas that indeed many of those are areas that Irwin Mitchell, as a firm I know, give advice, and some of those from our expert panel have some experience in particularly. So to conclude, I would say that conflict is all around us. It's how we deal with it that matters. And I hope that this webinar has given you an opportunity just to think about how you might be dealing with it going forward, given you some ideas. But I'd be very interested to see what comments and questions people are making on the chat and hear what those attending have to say. And of course, the expert panel. Thank you.
Thank you very much. Thank you. Thank you, Henrietta and Rebecca, for your whistle-stop tour through the post-Brexit journey regarding enforcement, and the way you took us through it, taking us on that journey to some beautiful places that hopefully we'll be able to go and visit in the not too distant future. My overriding image though of the whole process is your bowl of spaghetti, which I think is the perfect metaphor for how things are. I just wonder whether you consider that mediation is actually going to increase as a result of the current complications within the framework as it is, as
litigators, that is something that we encourage our clients to look to settle matters in a dispute resolution way, and I wonder whether you think that is something that's we're going to see increase.
So if I may start, yes, I believe we will see it increase. Certainly there's a push here in the UK for mediation to be used more and more. Master of the Rolls is particularly keen and is giving a lot of enthusiastic encouragement to people to use it. I think the very advent of the UN Singapore Convention on Mediation just shows what an important piece it is in the DR toolkit, and it's raised the profile internationally. I think the other thing is that more and more people are becoming aware of the fact that there is a possible cost sanction if parties unreasonably refuse to mediate. So if a party is offered to mediate and they don't agree, they go to court and win, and then later evidence of this refusal to mediate is brought along to a costs hearing, they are less likely to get their costs to the same degree as they would have done if they'd given it a go. So for a number of reasons, but whether we are going to come to a point where mediation becomes compulsory is something mediators are discussing. I think it is possible. Some other countries have actually made mediation compulsory for certain types of disputes. In Italy, that's the case for smaller disputes, in Greece as well. So there is a growing trend, but perhaps Henrietta might like to add to that.
Yeah, thank you, Rebecca. I think there is an alternative view also that as you touched on, that mediated agreements don't need enforcement. And indeed, some people have suggested that parties won't want to go to mediation because of the Singapore Convention. So I think it's going to be incredibly interesting to see what the consultation that the MOJ is about to start on acceding to the Singapore Convention suggests, because I think there is going to be some mixed views on its utility. But I think I mean, I think in principle I'm definitely in favour of it, because I think it raises the profile of mediation and allows people to get over the hump that some people have on mediation not being an enforceable means of resolving disputes.
Okay, thank you both. We had some questions come in before our event and also during it. I would just remind you that we have Cheryl, Henrietta and Rebecca here for a few minutes yet. So if you have any other questions, then please do type that in the question and answer box, and we'll endeavour to answer those for you. So one of the questions which was posed was before was whether you would recommend companies changing the forum in the standard terms and conditions, despite not knowing the laws in the same way as the home jurisdiction. They go on to say, sort of, is it worth sacrificing knowledge for enforceability?
So I'm happy to say a few things about this. I think it's important to differentiate, on the one hand, the governing law, and the other hand, what is the forum? And by forum, normally we're talking about the courts. Generally, it's a good idea if the governing law and the forum are the same if you're talking about the courts, because otherwise you've got to bring expert evidence of what the overseas law is, and that's going to cost significantly, and it's going to make it harder for the judge to apply that expert overseas law evidence rather than simply applying a law that they're already familiar with. But I'm very keen not to be in an ivory tower and put my former solicitor's hat on and say, you know, it's got to be English law, it's got to be the English courts, because I'm well aware that many clients of mine over the years, you know, if they'd insisted on that, possibly the other company would have said, well, sorry, no deal, we don't want to engage with you and contract with you. So as with all things, there's always a risk, and it's an important thing to decide how far should we push on this. And if it's a business opportunity, I wouldn't give it up for arguing over the governing law or the jurisdiction. But what I would say is that if you're looking at a country which is a civil law country, so where there's a civil code in place, so that's basically most of continental Europe, South and Central America, most of Southeast Asia, there you have a civil code. So if you have a contract written under the law of a civil code country, there's quite a lot that you won't actually see written into your contract. It's all in the background pursuant to the code. So it's necessary to find out what does the code imply automatically into this contract. So I would say, bottom line, of course, English law, English courts, if you can, if you're coming here from England, but don't let it be a deal breaker. If you agree something else, get the expert advice as to what it is that you're taking on.
Thank you. And sort of following on, I guess, a little from that in reference to the English law, I had a question raised in relation to London's current status as an arbitration centre of world repute, and whether you think that that Brexit will have an impact on that status. I think probably Henrietta, that's one for you.
Sorry, it takes a while for me to unmute. I think that I don't think that Brexit is going to have an impact on London Centre as an arbitration forum, because the New York Convention continues to apply. Nothing has changed on that basis, and I think that parties still see the arbitration community in London, both the arbitrators and the lawyers and the professional advisors, as very expert in arbitration. So I think, I think arbitration will be here. I know that the arbitration community does see some pressure from other cities across Europe, and particularly from Singapore. And that's where London International Disputes Week came into being. But I think arbitration is here to stay in London.
Thank you. Rebecca, I think this is one for you. What do you think about the possibility of states joining the Singapore Convention on Mediation, making the reservation then that that allows parties to mediation to decide whether to agree to the regime applying to their mediation?
I think that's a really fascinating area. The fact that the convention says each country that joins up to it can actually make that tweak and say in its national law, oh, we've signed up to the Singapore Convention, but actually parties in dispute, you can decide whether you want your mediation to be subject to it. Some countries have done that, but not very many. It will be interesting to see what happens with the UK. From my point of view as a mediator, if I was appointed as a mediator and the parties were saying to me when we were looking at the agreement to mediate, which is the agreement that you sign before you mediate to say this is the mediation procedure that you're signing up to, if somebody were to say, do you know what? We're not buying into the Singapore Convention, I'd then think, well, why not? And the obvious answer is, well, we don't want our agreement, if it's reached, to be enforced. Well, that would be a bit of a red flag to me as a mediator. And I'd be thinking, you need to come in good faith. Surely you want to abide by whatever it is you agree to. If you're saying before you've even started the mediation, you don't want international enforcement, that is going perhaps against the whole tenor of mediation. But I know that perhaps Hetty has been talking to others who take other views on this, possibly.
As I mentioned earlier, that I have heard from a leading mediator that he feels that parties who might be put off mediation because they feel that their assets would be enforced against immediately on signing a settlement agreement. But I share Rebecca's scepticism about what you'd think of a party that was wary of enforcement at the stage that you're about to enter into a mediation and their intentions.
Thank you. I think our final question just relates to settlement agreements, and the query is that presumably if you have a settlement agreement that has been breached, you would currently get a judgment on that basis and enforce the judgment rather than the agreement. And the question is, should we have exclusive jurisdiction clauses in the settlement agreements?
Yes, that's a very good point. If you're looking at having court recourse there, then yes, you would. But sometimes I see mediated settlement agreements that say, if there's a problem, we will mediate. So that is often a first point, but yes, having a backstop and thinking about that exclusive jurisdiction because of the Hague Convention. It will be interesting to see how many people just revisit their contracts anyway at the moment, contracts that are working perfectly fine, just to say, actually, shall we now make this an exclusive jurisdiction clause? Because it's in everybody's favour that we have certainty. It's so much harder to agree jurisdiction when you're already in a dispute. Really, you know, the cart has already bolted. So it will be interesting to see whether those in the commercial departments and corporate departments are seeing just that wish between parties to get that tidied up.
Thank you, and that brings us to the end of our webinar today. So I would just like to extend our thanks again to Rebecca Attry and Henrietta Jackson-Stopps for joining my colleague Cheryl and myself to talk us through this really important topic regarding enforcement. I think it's very clear from the contents of both the slides today and the discussions that we have had amongst us that it's very much a case of wait and see, and it'll be really interesting to revisit the position in the months down the line when we know a little bit more about the certainty of the situation. All our contact details, should you have any further questions, are on that final slide there. The session today has been recorded and the recording will be made available to you all shortly. I'd just like to thank you all for giving up your time to join us this morning and wish you the very best for the rest of the day. Thank you very much.
Thank you.